I can hear you.
Okay. Welcome everyone to the Oregon Crime Victims Law Center's annual Access to Justice CLE. This particular version, Access to Justice for Children, is an encore presentation from the original version, which was presented October 28, 2020. We experienced some technical difficulties back in October, and it was apparent we were trying to fit too much material into too little time, so this encore version is 30 minutes longer, and we have hopefully fixed the technical issues. The Oregon Crime Victims Law Center is a nonprofit legal clinic that provides free legal representation to crime victims to help them assert their rights in criminal proceedings. We provide this service to all Oregon counties and state, federal, and tribal courts. OCVLC opened its doors in 2009, and we now have 5 attorneys, a victim advocate, and a finance manager with offices in Portland and Bend. One of OCVLC's co-founders was Hardy Myers, and our annual Hardy Myers function, which is usually a dinner, but it's a Zoom function during the pandemic, will be held on April 21st, and we're delighted to be presenting the Hardy Myers Victim Advocacy Award to Meg Garvin this year. Meg is the longtime executive director of the National Crime Victim Law Institute, Lewis and Clark. My name is Erin Olson, and I'm the president of the board of directors of the Oregon Crime Victims Law Center. And I'm also one of the planners of this CLE. I will moderate today's CLE, which features some experienced advocates for children in the civil, criminal, and juvenile court systems. Biographical information for our 5 presenters are in the written materials, so my introductions of them will be brief. Allison Kelly will start us off today. She is the CEO of Liberty House in Salem, which is one of 21 child advocacy centers in Oregon. The Liberty House serves Marion and Polk counties. Allison is also an attorney and had a private mediation and dispute resolution practice for several years before leaving the active practice of law. Rahela Raymond will speak after Allison. Rahela is the attorney in charge of the child advocacy section of the Civil Enforcement Division for the Oregon Department of Justice. She supervises the assistant attorneys general who litigate dependency and termination of parental rights cases statewide, and she's worked for DOJ for 17 years. Emily Marr will follow Rahela. Emily represents parents and children in juvenile dependency cases for Sage Legal Center, a Portland firm that specializes in cases that implicate the Indian Child Welfare Act. After Emily will come Megan Johnson. Megan was a prosecutor for 17 years for the Washington County District Attorney, where she prosecuted child abuse and elder abuse cases and chaired both of the multidisciplinary teams. Now a civil litigator with Pickett, Dunnigan, McCall in Portland, Megan continues her advocacy for children and other vulnerable victims in her civil practice. Rosemary Brewer will be our final presenter. Rosemary is the executive director of the Oregon Crime Victims Law Center. She was a prosecutor in Baltimore, Maryland, and Atlanta, Georgia before joining OCVLC in early 2012. The presenters will refer to the case study that was included in your written materials. I've been told that there were some challenges in receiving written materials by certain participants. And all I can tell you is that there were 3 separate emails sent out in the same format as the Zoom link was sent out that had a link to the written materials. And I'm told that they might be too big to email directly. So we're doing our best to get them to those of you who have said you didn't receive them, but we would ask that you check your spam filters for the 3 emails that came out with the links to the written materials. The case study is fictional, but the general scenario is not. The pandemic has increased the risk for child abuse and neglect because of increased stressors and loss of financial and social supports. Despite the increased risk for child abuse, the number of emergency department visits related to child abuse and neglect has decreased significantly, and the official reports to child protection agencies have declined across the United States by between 20 and 70%. This is attributed to decreased in-person contact between children and mandated reporters, such as teachers, social workers, and physicians. Once children are back in school, there is a fear that reports will increase dramatically. As the presenters give their talks to you, you will have the opportunity to ask questions through the chat function at the bottom of your screen. We'll try and stay on top of those questions. And finally, I would just ask that you please make sure you stay muted while on the Zoom channel, because otherwise we might get some feedback. So with that introduction, Allison, you can take it from here.
Thank you so much, Erin, and it is really an honor to be here today, and thank you and all of the team at Oregon Crime Victims Law Center for all of the work you do. So with that, I am going to share my screen and go through a PowerPoint that is included in your materials. There are other things also included in your materials. There's a very short white paper that I put together that summarizes what I'm going to speak about. There is information about the statewide network of child advocacy centers called Oregon Child Abuse Solutions that is headquartered up in Portland. There is some information about the Adverse Childhood Experiences Study. And finally, there are sample protective orders both for civil and criminal actions. So with that, let me get to my screen and we'll go from there. So, all right. So what I am going to do is just give some context to this topic, and the fact pattern that is included in your materials, you know, really represents so many different children that are seen across the state. You know, child maltreatment happens in every neighborhood, in every community throughout the state of Oregon and nationally. So for me, my background, as Erin said, I am a licensed attorney. Mediation, dispute resolution was my specialty. I have had over 20 years experience in public policy, collaboration, and dispute resolution, and I've been leading the team here at Liberty House since 2013. Liberty House is a child advocacy center. We have 46 staff members, including medical providers, forensic interviewers, family support specialists, and we have 9 licensed therapists who provide trauma-focused therapy. I serve on the board of directors of the statewide Oregon Child Abuse Solutions, and I'm House board chair. So just briefly, the scope of the problem, it really is a global problem that manifests itself locally, and it really alarming in both scale and impact. So nationally, in 2018, over 33.5 million reports of child maltreatment were received nationwide, and over 677 confirmed cases. So that's about 10 average size Division I football stadiums. It's just big. And so I think that's kind of an average size picture of the stadium. Oregon Department of Human Services received 89,000, almost 90,000 reports. And I can tell you that over the last few years, just the 2 counties that we serve, Marion and Polk counties, were responsible for 10,500 of those reports. And we always want to make sure people remember that the number of founded cases is not the same as true prevalence. The true prevalence of abuse is notoriously difficult to pin down because of all the disincentives to reporting, and also the fact that so much of this happens in secret, in quiet. So with that, I also like to help people understand the research around the cost of the problem. There is research to support that the average aggregated lifetime cost of child maltreatment is over $200,000, about $210,000. And so if you multiply that by the founded cases in Oregon, the state of Oregon racks up $2 billion of new aggregated lifetime experiences every year, based on what we know. So why the high price tag? And that is really where we want to dig into the adverse childhood experiences research. Again, references which are included in your materials. And for the first time, that 1998 study established the strong correlation between adverse childhood experiences, such as child maltreatment, having a parent with mental illness or drug addiction, parents who are divorced, and so forth, and physical illness and disease, things that can show up either later in childhood or in adulthood. Cancer, heart disease, diabetes, seizure disorders, among many others. And it really is stunning to hear survivors of childhood trauma describe their experiences. And in so many cases, it actually manifests itself with seizure disorders. And it takes a very well-trained neurologist to try to pin down what that's all about. So with that, these two diagrams are from the ACEs studies. It's ACEs study and really does lay out that relationship between childhood adversity and the adverse physical and mental health outcomes, and also the relationship between childhood trauma and neurocognitive processing. One of the best resources on that topic is The Body Keeps the Score. If you work in this field or are interested in learning more, I highly recommend this book. This preeminent researcher did an amazing job of making that link between how trauma affects children neurologically and even in their neurological processing. And some of it stands to reason, right? One of the points that he brings out is that psychologically, developmentally, children are at a certain stage in their age growth, you know, age 2, 3, 4, and on up, are fairly egocentric psychologically. And where that comes in is when experiences happen to children, it is normal for children to think that it might be their fault. It just, you know, all these bad things are happening to me, therefore I must be bad. That's the shame talking. And also, you know, did I cause this is a really common question we hear children ask. And it takes specialized trauma-focused therapy to unravel those beliefs and those stories that children learn to tell themselves so that they can not carry around that burden. But those feelings that I just tried to describe from a child's standpoint, they don't have words around it. It's just a sense of this deep, dark shame. So just understanding the role of fear, guilt, shame, hypervigilance, that overdeveloped sense of responsibility, and how crippling they can be. Also, what we have learned over the years through research is that trauma can inhibit the development of the frontal temporal lobes, the executive functioning. That's the part of the brain that gives us the emotional regulation. And it can lead to hyperdevelopment or greater development of the emotional centers of the brain, the amygdala. And that stands to reason, right? Like if the CLEs that I've attended, even on Alzheimer's, on brain functioning, the more that you use of your brain, the more neurological development you will get. So if you are in a state of constant hyperarousal, the emotional centers of your brain will be hyperdeveloped, and that means there's only so much development a brain can do, and that means that the very often the executive functioning is less developed. Everything seems like a saber-toothed tiger to children. So with that, and we'll take a look at a picture of that. And also trauma affects how memory is encoded in the brain. Memories aren't well integrated. They can be dissociated. And so when it gets to the point of inviting a child to describe the experience that they have been through, their description, their recounting may come out in fragmented ways. And if they are not being interviewed by somebody who has had special training, it can start sounding like inconsistency. And if you have doubt in the form of the interviewer, that could lead, those are the types of things that lead children not to have confidence in the adults around them and to possibly recant. And you know, all of these dynamics can set a victim up for failure. So here's a slide. This slide is a PET scan of the brain of a child who grew up in an orphanage in Romania. But this is really an example. On the left-hand side, you see the red, the more lighted up version sections of the brain. That's the frontal temporal, the executive functioning. On the right hand, or that's on the left hand side. On the right hand side, as we're looking at it, you see a lack of development in that frontotemporal area and more hyper development in the emotional center, which is what you see at the bottom. So what's the answer? And in my white paper, I wrote that kind of the depiction that we see on this slide here, and this slide comes from the Oregon Child Abuse Solutions Network, that when there are always going to be multiple agencies involved in responding to concerns or allegations of child abuse or neglect. And on this slide, we see examples of some of them. You know, often the first people to notice are schools. DHS is going to be involved, law enforcement is going to be involved, the medical provider, district attorney, district attorney's investigator. And so there are a lot of people that a child might have to talk to. And this research, you know, is 30, 35 years old. That in the past meant that a child might have to describe what they've been through multiple times to multiple different adults. And for those adults, if they do not have the specialized training in interviewing children, they are not going to know that the way they ask their questions, the tone they use, the presence they use, the pace they use, the environment, all of that could have an effect on how safe a child feels in describing what they've really been through. And again, there's so many disincentives. A very common scenario that we see is children whose parent has moved in with an unrelated caregiver, often an unrelated male caregiver. And ostensibly, you know, that could be for all kinds of reasons, to help pay the bills or whatever. And so if that unrelated male caregiver then is involved in harmful acts to the child, there's a disincentive, because I don't want to see mom cry. If we get kicked out, where are we going to live? All the things. So with that, without coordinating that response, the having to do those multiple interviews sets up a situation where that victim's description can be misconstrued. So the antidote to that is coordination. So what we want to do is coordinate the response. And your CACs, there are 21 throughout the state of Oregon. Several of us serve more than one county, and they are really the hub of that response. And the MDT statutes that we see beginning in ORS 418747 and beyond, and throughout that section of the statutes, really describe, set forth what that system is designed to look like. So with that, this model manifests itself in the multidisciplinary team convened by the district attorney in each county. And the easiest way to describe it is that your child abuse center, your child advocacy center, is a single point of location that should be the hub, and all the professionals will come to the child rather than the child having to go out to all those professionals. There are provisions in the statute. ORS 418794 describes what we can and cannot do with a video recorded forensic interview. Forensic interviewing is itself an art. There are Oregon forensic interviewing guidelines that you can find on the DOJ's website, Child Forensic Interviewing Guidelines. And the best practice in the field based on research is that those forensic interviews are video recorded. The forensic interview is just a carefully created environment for the child to describe what they have experienced. And I want to be careful here that we say children advocacy centers are designed to be neutral and objective. So they don't use leading questions. They don't even use direct questions. It's a series of open-ended questions designed to create safety so the child can describe what their experience has been. So for example, several child advocacy centers in Oregon provide both a medical assessment and the forensic interview, and also family support or victims advocacy, that first level of crisis intervention. And some will produce a report, either medical or a summary of that forensic interview as well, and that can be admissible in court proceedings under the medical hearsay exception. What I was about to mention before is that there are restrictions on whether we can release that video recorded testimony and our report, and those are found in ORS 418-794 and ORS 418-795. Each CAC is a little different. You may be well familiar with the CAC serving the area in which you practice. And the other thing that I'll mention is that child abuse assessment is a subspecialty in the field of pediatrics. There is a big difference between a medical provider who has had that training and one who hasn't. The training really allows that medical professional to pick up on the nuances and to understand what we call sentinel injuries, or injuries which in and of themselves are indicative of non-accidental trauma. So we really try to encourage investigators to make referrals to the Child Advocacy Center because they have the specialized training, they have the specialized forensic interviewers, and that family support. What our district attorney in our county has said many times is that when children go through the CAC, because they've had the benefit of all these wraparound services, they are better prepared for testifying in front of grand jury or testifying in their court proceeding. In the CAC model, you typically see an appointment will take as long as the child needs. It is designed to create safety and space. Children, it's a very trauma-informed model, so a single appointment could be 3 to 4 hours, and it just is designed to help that child feel at home and that they can trust, and same thing with the services. So in the materials, I included the brochure from Oregon Child Abuse Solutions. There was a study done in 2003 that demonstrated children whose cases went through the CAC from an access to justice framework. More charges were filed, more plea bargains were achieved, and for cases that went to trial that achieved longer criminal sentences, and that's just about holding offenders accountable. It's coordination, and it is, again, the best practice in the field. So what about COVID-19? We know, as Aaron said a little earlier, reports to the DHS hotline fell nearly 27%. CACs across the state has seen roughly 15.3% fewer children. I can tell you at Liberty House, we actually saw more children during the same time period in 2020 than we did 19. And that's because we worked really hard to stay open and to make our services available. And as Aaron said, it is very concerning. And once we begin to have more eyes on children, we expect the referrals and the calls to the hotline to increase. We are seeing anecdotally more cases of more severe physical injury to children who are far younger, infants, toddlers with multiple broken bones, having to be referred up to OHSU. And but the governor was able to allow us to stay open. So with that, that lays the foundation. The fact pattern that was included in your materials, there were a lot of really important details, and that is, as Aaron said, it's a composite. So happy to answer any questions, and I'll turn it back to you, Aaron. Thank you again for the opportunity.
Thank you, Allison. I don't see any questions in chat. We'll take questions at the end as well, if time permitting. But now let's go ahead and move on to Rahela.
Thanks, Aaron, and good afternoon, everyone. Thank you for inviting us again and sort of continuing this conversation that we started a few months ago. So first of all, I want to just state a disclaimer because I'm employed by the Oregon Department of Justice. I want to just make sure that everyone is aware that my comments are my own and should not be attributed to DOJ or to the Oregon Department of Human Services. So what you have in your materials, and I'll probably have to share because I think some people have gotten materials, others may not have, are, so my specific materials start on page 44 and go to page 58. If you will bear with me, I will see if I can share. Is everyone able to see the PDF that shows graphs, or at least one graph for now?
Yes, we can, Rahela.
Thank you. Thank you. So what I hope to do today in my 15 minutes is to break up my presentation in 3 ways. First, I just want to talk a little bit about COVID and reports to the child abuse hotline, and I'll spend a few minutes doing that. And then I'd like to be able to walk everyone through what justice for Jimmy would mean in the child welfare system context. That would also include juvenile court. And then the last minutes that I have, I want to talk a little bit about the confidentiality statutes that govern child welfare records. And so my materials that are divided up, that are between 44 and 58, are sort of follow that sort of logical progression in terms of my presentation. So I'm hoping that we can all follow along. So first, let's talk about what impact COVID has had on reports, specifically mandatory reports of child abuse. And before I launch into that, I want to make something clear. It is that the reports of abuse have declined, but not the agency, the child welfare's ability to be able to investigate those. So the child welfare piece of the work has not changed, other than there's just less reports and less investigations because there's less reports. So child welfare still makes face-to-face contacts with victims and their families, still reaches out to collaterals, still coordinates investigations with law enforcement. So all of that work has not changed. It's just the percentage of calls and the percentage of assessments is what has declined. So the 3 graphs that are here all depict the same information, but just in a different way. We have a table graph and 2 line graphs. I'm actually going to focus on the table graph because I just think better that way with that visual. And I want to just highlight about 4 or 5 points in terms of comparing data. What you have before you are calls to the hotline, both those that were screened and those that were assigned for CPS assessments from April to December for the years 2019 and 2020. Just to get a comparison of what happened to us in 2020 compared to what numbers looked like in 2019. The other thing about this graph is, as we all know, there's a natural progression or even a decline actually in calls over the summer when kids are not in school, also over breaks during the school year, such as spring break, break into the winter break in December. So we expect calls to go down during those times. And I think the graph that's before you reflects that. But so let's do a little bit of just sort of adding some of these numbers. Just in April, which is the spring of 2019, we had about 84 total calls, of which some were assigned and some were just closed at screening. And that was April of 2019. Compare that to April of 2020, it was 5,000. So there was a decline of 3,400 calls just in the very beginning of COVID. That's a pretty drastic impact. Then when we look at the summer, July of 2019, there was 6,500 calls to the child abuse hotline. And then July of 2020, there was a decrease of about 700. There was only about 5,800 calls. So it's still a big number, but it's not that big of a disparity as we saw what happened in the beginning of COVID. And of course, it's the summer break. So we do expect calls to drop off. And just in 2019, between the school year and the summer break, there's a drop off of almost 2,000 calls. That sort of pattern of less calls during COVID continues throughout the year, as you'll see. In September, which is the beginning of the school year, we see in 2019 calls going on the uptick again to 7,400 approximately. But in 2019, for that same September period, in 2020, for the same September period, there are 5,900. So there's a discrepancy of about 1,500. So all of this is to say, yes, COVID has absolutely had an impact on the number of mandatory reports made to the child abuse hotline. And of course, that impacts child safety across the state. That's just something that we have to acknowledge. Hopefully after COVID, there will be, calls will go back to the regular volume, and DHS and other system partners, such as Allison and other child assessment centers, can really once again work to try and protect children in our state. With respects to Jimmy, I want to now move on, if I may, to Jimmy. And for that, I'm actually going to bring up, just bear with me here. I think it will be helpful to talk about Jimmy's case with a timeline illustration of a juvenile dependency case. And so I want us to look at this specific, and I'm going to see if I can make it a little larger. Just bear with me, please. There we go. So we will talk about Jimmy moving through the system in this context. I'm also looking at my time as well, as I don't want to run over like I did last time. So please bear with me as I just sort of record some time here. Okay. So in this instance, so this is the second time that Jimmy has now been hurt, and finally we have a call to the child abuse hotline or directly to DHS and child welfare. So what would happen here is that both DHS, child welfare, and law enforcement would likely show up at Jimmy's school. And this is all pre-shelter hearing, pre-juvenile court. This is just the initial contact with Jimmy. And as Allison said, in order to be not further traumatize Jimmy, what child welfare and law enforcement would do in this instance is immediately schedule a forensic interview. Take Jimmy to the hospital. Perhaps there is a designated medical professional there, or speak to someone at a child assessment center and be able to schedule an appointment for Jimmy immediately to be seen. In order to do that, child welfare would actually have to take Jimmy into protective custody. So that's what they would do immediately when showing up at the school, is Jimmy would be taken into protective custody. In this instance, I can with confidence say that that would occur without a court order, frankly, because of the visible injuries to Jimmy. And so, and in order to then move forward with that interview and assessment, the DHS would need protective custody, and that's what they would do. Jimmy's injuries would be both documented by the designated medical professional or the doctors in the emergency center. Those injuries would also be photographed, and that would be a requirement to make sure that everything is fully documented. Hopefully Jimmy would then make disclosures. Based on Jimmy's disclosures, the agency, child welfare, may also then actually go to Jimmy's house and assess the welfare of Jimmy's siblings. And this is where I think the child welfare system, as well as juvenile court, is really particular. It's different than other systems in this way, right? Not only does the system look at Jimmy, our target child, the injured child, the victim, but also at his siblings, and seeing what should be and could be done to protect the siblings. Are the siblings also at risk because of the parents' conduct? They would, of course, talk to the parents. They would talk to collateral contacts. So the next thing after Jimmy is taken into protective custody is there would be a shelter hearing. And at that shelter hearing, in this scenario, I can also say with confidence that Jimmy's siblings would also come into care. The agency would actually remove Jimmy's siblings as well, because they are younger, much more vulnerable, and given the extent of Jimmy's injuries, the likelihood of threat of harm to the twins is quite high. And so the agency would end up removing all three children. They would have a shelter hearing 24 hours after removal, after taking protective custody. There would be attorneys appointed for Jimmy, his siblings, and the parents. The next thing that would happen is likely, upon removal, Jimmy and his siblings all would have likely been placed in foster care, but hopefully with a relative or a friend or someone known to Jimmy and the twins. Within 60 days of removal, or 60 days, excuse me, of the shelter hearing, there would be a hearing on the petition itself, on the juvenile dependency petition. Parents would either make admissions or we would be set for trial. The next thing that would have to happen after that, once jurisdiction is established, is periodic reviews and also permanency hearing to assess the parents' progress in services and to assess what should ultimately happen with Jimmy and his siblings. If the parents make progress, we move towards a reunification plan. That can happen pretty quickly. If they do not, then we move towards a plan of something other than reunification. That, in a nutshell, is sort of the length of a dependency case. You can look at this specific flow chart. It gives you timelines, it gives you timeframes, and what happens at every specific juncture. But the biggest thing about the juvenile court process is focus on reunification, focus on Jimmy, but also focus on his siblings. So it's justice for the parents in terms of getting their children back. It's justice for Jimmy in terms of what happened to him. And it's justice for his siblings to make sure that they're also protected. Third, I will move on to probably what this group wants to know is the confidentiality around child welfare records. And I will take about 4 minutes to do that. I've provided you with a compilation of statutes, and I'm not in any way going to go over all of them, but I wanted them in a nice, convenient a way for everyone to have them. So the first, there are a number of statutes that govern child welfare records and juvenile court records. The very first one is 49225, ORS 49225, which governs the confidentiality of child welfare records. What is important for this group to know is that DHS Child Welfare maintains records under the mother's name. So records pertaining to Jimmy, his siblings, the father or fathers would all be under Jimmy's mother's name. Those records would include Child Protective Services records, juvenile court records, adoption records, police reports, relative information, placement information, treatment records. It's a whole array, a plethora of information that would be in that file. Jimmy and his siblings would be a part of that file. I'm not going to read the law to you, you guys can, but the very first section talks about the fact that these records are confidential, and that's really important, and that they only may be disclosed in connection with child welfare services and child welfare policies. So that's sort of the takeaway in terms of child welfare records as a whole, is that they are indeed confidential. Another set of records that are contained within a DHS file are Child Protective Services records. These are reports and records compiled under the Child Abuse Reporting Statute. These records under subsection 1 of the statute, it is ORS 419B 035. I'll see if I can quickly find it in my materials here. Here we go. It is on page 54 of the materials. The very first section of that statute says that these are confidential, not open to public inspection. And then there are a list of exemptions to that in terms of who can access the records. I want to draw your attention to subsection 1I in this instance. And that says that any person can request a record, a CPS assessment and all of the attendant records to that, where a child has suffered serious physical injury or died as a result of abuse. In this instance, given Jimmy's injuries, I could see this specific section actually applying, and the agency providing records to any person that requests it. Those records would likely include the CPS, the child abuse assessment, the police reports, any medical reports that may have been gathered. I think that would be about it as I think about all of the types of records that would fall under this statute. In terms of police reports, if there's an open investigation those would not be released without first talking to the detective or the DDA on that specific case. And in this case, we know that there were, in fact, there were criminal charges filed as to Jimmy's parents. And so when that investigation, not necessarily the prosecution, but when the investigation concluded, then those records would be available. The last type of records are juvenile court records. And once again, no surprise to this group, juvenile court records are also confidential. That specific statute is ORS 419A255. Juvenile court records are confidential. They're not open to public inspection, except there's two sections, except under subsection 3 of the statute. With permission of the court, a person may apply to have those records disclosed, or under 419A258, also in your materials, where any person may file a motion to inspect or obtain a copy of the records. I'm now going to turn it over to Emily Marr, who will walk you through more of the juvenile case process. And Emily Marr would be an attorney that would likely be appointed for Jimmy or his siblings to represent them in the juvenile dependency case. Emily?
Hi, thank you. I'm Emily Marr. I'm a juvenile dependency attorney. I represent both parents and children. So in this case scenario, as Rahila pointed out, I would be appointed to represent Jimmy. DHS would be, after the preliminary hearing, if removal is granted, his legal guardian. And as a dependency attorney, the scope of my representation is limited to the dependency case. However, best practice standards encourage dependency attorneys to take limited steps to protect the child's rights by notifying the legal guardian, in certain instances, the child or the court, of collateral issues that might occur. Included in your case materials is specific standards for representation in juvenile dependency cases. Standard 2G addresses the child client's lawyer's duties on collateral issues. 2G states, if a child client's lawyer, in the course of representing a child client under the age of 18, becomes aware that the child client has a possible claim for damages that the child client can't pursue because of the child's age or disability, the child client's lawyer should consider asking the court that has jurisdiction over the child client to either appoint a guardian ad litem, for the child client to investigate and take action on the possible claim, or issue an order permitting access to juvenile records by a practitioner who can advise the court whether to seek an appointment of a GAL to pursue a possible claim. Also included in your materials in my section is an article written by the Oregon Child Advocacy Project regarding this issue. Based on the information we have today, I see two potential collateral issues for Jimmy. There's a civil claim for the doctor's failure as a mandatory reporter to make a hotline call. There are multiple red flags throughout this scenario for Jimmy. One, that he was in his underwear yet stepping into the bath, but most importantly, the fact that the family was not aware that Jimmy was missing and had to be notified by a stranger after the stranger took Jimmy to the hospital and returned home. Obviously, that's a significant period of time for a 6-year-old to be missing. The other is because Jimmy's mom is being criminally prosecuted for charges arising from abuse against him, I would also be looking to potentially seek a referral for a victim's rights advocate for Jimmy. So those are the two issues I see that arise that require me as a juvenile dependency attorney to take limited steps of protection for Jimmy. Since Jimmy is 6 years old, it's important for me to meet with him and to determine if he has the capacity to direct me as his attorney. I would conduct a home visit with Jimmy shortly after the preliminary shelter hearing, as it's unlikely Jimmy was at court. So this would give me a chance to establish a relationship with Jimmy, explain my role, and make a determination about next steps for him. The child client's lawyer should determine whether the child client has sufficient maturity to understand and form a child-client relationship, and whether the child client is capable of making reasoned judgments and engaging in a meaningful communication. So that's why the home visit becomes really important for me in determining what my role will be for Jimmy. It's unlikely that Jimmy, as a 6-year-old, has the capacity for considered judgment, at which point in time I would make decisions that are in his best interests. If I had a client with considered judgment, I would first want to consult with them on these collateral issues before taking any action. I could see quite a few scenarios, particularly with older children. It would be important for me to have a discussion about whether they'd want me to seek the collateral action, as that may be something that they do not wish to have done, or it could potentially affect DHS decision-making on placement or other services. The first step I would take for Jimmy on this case would be regarding the civil issue. So I would notify legal parties of the collateral issue identified. I could ask the court to appoint a guardian ad litem to represent the client, investigate and take action on possible claims, and included in your materials is a letter from a Washington County judge that did that. I will typically make a referral to the Oregon Trial Lawyers Association, OTLA, so the Oregon Trial Lawyers Association, or if I know an attorney who specializes in that matter, I might engage with them. The referral form for the OTLA is included in your materials today. In this case, I would make the referral to OTLA. And what typically happens, I fill out that form, I will receive contact back from that assigned attorney, talk about the case and determine if it makes sense to move forward with obtaining additional information for that attorney on the claim. So if the attorney determines we have enough information to move forward, I will file a motion for authority to release records and a protective order, an order authorizing release of records and protective orders. So that's also included in your materials today. And what you'll notice is that the statutes Rahila outlined earlier are included in those motions and orders. The records I typically have in my juvenile file that I think is relevant to the discussion on the claims today is I'm going to have court orders. I'm going to have the preliminary hearing report from DHS, the reasonable efforts documentation we call it. I will likely have the 307 assessment. I could also have previous 307 assessments if the family has had contact previously with the agency. I'm going to have a copy of police reports, interviews, and medical records. I will add the caveat of, since there is an open criminal investigation, I might not have all of those items in my possession yet, but at some point in time, we will have those. I will also have any evaluations that have been done on Jimmy, whether that's mental health, educational. And if there has been a previous case with a family, I would have potential previous psychological or other court reports on the family. The last collateral issue on this case that I would be looking at are regarding the criminal charges against Jimmy's mom. I would ask the legal guardian, so in this case, DHS, and Jimmy has an assigned caseworker, to make a referral for a victim's rights advocate for Jimmy. I would go to the agency first, ask them to do that. If they needed any assistance with that, I would be happy to do that. But since DHS is the legal guardian, I would look for their assistance in the referral process. And that is my presentation. Does anyone have any questions, Erin?
I see none in chat.
Okay, well,
doesn't mean they won't come up later.
Well, I will hand it off to Megan then.
Thanks, Emily. I'm gonna, let's see, get my slide ready to share, my screen ready to share here. Bear with me, as Rahila says. It's just taking a minute. Let's see. I'm sorry. Okay, now this. Can you see my presentation now? Yes, okay.
Yes.
All right, thank you. Let's go like this and see what happens. Can you see it clearly, or do you see the presenter view?
We see a big first slide and then a next slide showing. You had it just a minute ago. You had a better view.
How's that?
That's good.
Okay, thank you. Thanks for holding tight, everyone. I appreciate it. So as Emily just said, as the dependency attorney, she has access, a unique level of access to Jimmy, as do a few people in our society. And that's because Jimmy's been taken from his parents and put into protective custody, and DHS is now involved. And in looking at this slide right here, the one thing I want to point out is that for kids like Jimmy, the world of people around them that are in their corner, the world of people around them that discuss them, talk about their well-being, talk about how they're doing, talk about what's happening to them, is really small compared to other children in our society. So for Jimmy, the people that are in his corner, looking at him, seeing him, understanding what he's going through, thinking about his situation, is pretty limited to DHS, his dependency attorney, police, victim advocates, both at the DA's office and at the police department, the criminal prosecutor, staff and support people at the Child Advocacy Center where he was seen, and then maybe a greater multidisciplinary team if his case is reviewed. Different counties handle that differently. And I just think it's worth taking a minute right now to look at this list of people that are in Jimmy's corner who could issue spot for him and think how small that world is. You know, if another person who isn't losing their kids to DHS because of abuse and neglect and failure to support their children, if something bad happens at the emergency room, if a doctor blows it, if somebody fails their kid along the line, there are so many people clamoring to hold everybody accountable on behalf of that kid. People are saying, what's up with the emergency room? What's happening there? Somebody needs to look into this. Somebody needs to get a lawyer. You all need to bark up this tree and make this change. And Jimmy just doesn't have those people in his corner. And I think it's also interesting to point out, this is my experience in anecdotal observations, is that many of the people on this small world, this small list of people who might issue spot for Jimmy and see that he that he was hurt and that somebody might be responsible for that, in addition to his parents, some of those people think that or wonder if they're referring to a civil attorney is something that they ought to be doing, if it's in their lane, if it's appropriate for them to be doing it. I'll point specifically to police officers. Most police agencies, most detectives that work on these cases have been doing it for a long time and are very well versed in their standards and what needs to happen and the system. They're some of the brightest people I've ever met in my life. But yet detectives who are seasoned and been police officers for longer that have been detectives and officers for decades will say to me, I'm not really sure I should be bringing up that Jimmy needs to get an attorney. There's this hesitancy or this feeling that it's outside of their lane to speak up and say that maybe the hospital hurt Jimmy, that the police officers, victim advocates, multidisciplinary team, staff at child advocacy centers, criminal prosecutors, there is a sense in the few people that are in Jimmy's corner, there is oftentimes a strong sense that it is somehow inappropriate or not in their line of work, somehow not in their list of things to do, to speak up and hit an alarm bell and to try to trigger civil legal protection and action for Jimmy. And so to the extent that those professionals are in the room today, I think it's worth thinking about, and as a society as a whole, I think it's worth recognizing that people like Jimmy have fewer people in his corner. And those people, no matter how excellent they are at their careers, there's often a sense that they ought not to or should not get involved that's in something that isn't right up their alley of things to refer and to deal with. So the civil world of protection for Jimmy, where we start, attorneys that do this work, is we have to figure out whether or not Jimmy has a claim and if it's worth pursuing. And I agree with Emily when she says that she sees two issues here, possibly with regards to Jimmy. And I'll talk about the first issue that Emily raised, which is she saw perhaps a civil claim. She saw a doctor failing to make a mandatory report at a police department. And she saw a couple of different reasons why that doctor ought to have made a mandatory report when it saw Jimmy the first time. And so the civil attorney is charged with figuring out whether or not the hospital has the right information, whether they have protocols, whether they blew it on this case, are they blowing it on other cases as well? And then also, if they were negligent, what are Jimmy's damages? And those are the first two fundamental claims that we have to come up with an answer to in order to advise these kids or the guardian of these kids whether or not they have a claim that's worth the time and energy to pursue. And the first thing that we do is we ascertain the client. Jimmy was, as you heard from Emily in this hypothetical, he was placed into protective custody. And as you know already from her presentation, generally DHS has granted guardianship of these kids. So I know that Jimmy is 6 years old and that he's not, as Emily said, when she said decision making, I can't remember the phrase she used. He's 6 years old, and the first thing that we have to go about doing is securing this kid a guardian ad litem. And then we have to investigate. Jimmy's civil lawyer needs to obtain hospital records, primary care records, school records, and more in order to figure out if Jimmy has a claim. And the lawyer that's working on behalf of Jimmy often is under sometimes really tight deadlines. There can be a matter, I've had instances and when I've been contacted and there's a matter of weeks before I need to get this certain paperwork done to preserve my client's claims. And it's really hard when that happens. And as you got a sense from both Rahila and Emily's presentations about DHS, we find ourselves, by virtue of the construct of the statutes, oftentimes running into a brick wall when it comes time to obtain records, the records that we need to ascertain if Jimmy has a claim. And those records again that brick wall again is a product of the statute, and it really competes with that really strict timeline that we're under in some instances to figure out if the kid has a claim. Obtaining records is hard from our perspective. Dependency attorneys, there are no bright lines, but likely it depends on what's being sought and whether or not there's an exception to confidentiality, but they're likely a no for giving us records. Criminal court, the DA, police, almost always a no in terms of a source for obtaining police reports and the contents of the DA file. I don't think foster parents can obtain records. Aaron Olson knows that better than I do, but I think that that's a flat always no, not even a potential option. And then public records requests from DHS are almost always denied. And so this concept of needing to investigate a claim on behalf of a kid who's been taken into custody by the state, protective custody or more by the state, and then there's a bunch of statutes that heap on top of that wrap up all of the records that we need to see to ascertain his claim is really, really difficult. And it's time to get creative, because we can't just wave our hands and walk away and say, well, it's too hard to help somebody like this kid. I mean, that's not what we're here for. So I say that it's time to reach out and consult with the large handful of lawyers that do this work. File a lawsuit. And if you can, if you have enough information to do so, obtain court orders and subpoenas for records. You can set up and utilize a conservatorship. I came across recently information, an attorney named Brooks Cooper has conjured up a legal proceeding called a limited protective order proceeding. His materials on how to go about doing that are in the CLE materials. It looks brilliant to me. I haven't had an opportunity to try it myself, but it's in my arsenal of things that I could and would use if I needed to get documents, records for a kid like Jimmy. I encourage all civil attorneys to take a look at that paperwork in your materials. It's really good stuff. And again, collaborate and brainstorm. I'm not able to evaluate how to get records in these cases on my own. And I find the other attorneys that do this work often call each other and talk and try to come up with a plan. It's time to get creative and it's time to work hard. It's not time to walk away with our hands up and say, well, this is just too difficult. The overview of his case involves obtaining his records, investigating and discovering what is happening at the hospital, and hiring experts. We will hire experts to talk about hospital standards of care and to help us understand damages and how that would work out in this case. And I want to talk a little bit about successful litigation outcomes. I think important for everyone to understand is that a well-positioned and well-postured lawsuit against an entity that was negligent and failed a kid can sometimes change hospital and/or entity practice and procedure. Some of us that have been doing this for too long get a little jaded on this point, excuse me, and start saying, well, nothing's ever going to change. But only if you try can you change something. And if the hospital had a gap in its response to child abuse, had a gap in its training or in its protocols when this kind of stuff comes through, it's only through civil litigation that those gaps get explored, identified, and hopefully changed. And I'd also like to point out that, as I did in the beginning, kids like Jimmy, not only do they have very few people in their corners, but as you can, I'm sure, surmise, they often don't have very many legs up in life. They don't catch lucky breaks. Kids like Jimmy, kids that go into DHS custody, they catch rough breaks, and they catch them over and over and over again. And if the hospital is responsible for hurting Jimmy, and if he can obtain a financial recovery, that can be a leg up for a kid who isn't otherwise going to get one in this life, or not very many. And I'd like to point out that he's 6 in this outcome and in this case. And if he does indeed recover financially from the hospital, his funds are invested and protected by a conservator. So bad parents, other bad actors, other kind of crummy people in his life cannot take that money. It gets invested for him and can be the gift that launches him out of a really rough transition to being 18. So as Emily also kind of astutely mentioned during her presentation, the second issue with regards to what's going on with Jimmy is that his mom is facing going to prison for what I would imagine, based on my experience, would be a really long time. And Emily thought that it was possible that Jimmy might need an attorney to help represent him or be present for him during his mom's criminal process. He's entitled to constitutional and statutory protections as a crime victim. And there are some civil lawyers, many that I saw in this Zoom room today, a big handful of them that are able to assert those on behalf of their clients. Some attorneys can do both, pursue civil claims and represent a client and represent them as a crime victim rights attorney. But everyone can access the Oregon Crime Victim Law Center. And that's where Rosemary comes in, and the Oregon Victim Law Center. I'd like to pass it over to Rosemary to talk about the process of enforcing constitutional crime victim rights and the other work that can be done for kids like Jimmy and Jimmy in the future. Rosemary?
Thanks, Megan. Let me get my screen up. Okay, can everyone see that? Okay.
Yes.
So the Oregon Crime Victims Law Center, as Erin mentioned at the beginning, is a nonprofit legal organization that provides free representation to crime victims throughout the state. We have 5 attorneys. We have represented victims in nearly every county in Oregon. We represent a large number of children who are victims and are dealing with the criminal justice system. With, like the other attorneys mentioned, with a case like this and representing a child, there's unique issues that you're going to face. And to start with, in looking at our case study, you have a victim, Jimmy, who is 6 years old and likely has cognitive impairments. As both Megan and Emily pointed out, he is unlikely to be able to make decisions that he needs to further his own interests. So this is where a victim's rights attorney can come in and make sure that his constitutional and statutory rights are protected while his mother goes through the criminal justice system. He's too young to assert his own rights. It's going to be pretty important for him to have somebody who is able to do that. And if you look at the case, who is the victim here? Obviously, it's Jimmy. But because DHS is his legal guardian, DHS is also the victim and needs to receive notification. Where do we get our cases from? Most often, victims are referred either by the advocate or the deputy district attorney in the DA's office. We are referred cases by DHS. We're referred cases by dependency attorneys. And sometimes family members will find our website or hear about us and contact us. So why is it so important for a victim like Jimmy to have an attorney? There's a number of issues that we can address, and we are an organization. We provide limited representation, and we, confine ourselves to victims' rights issues. But that does allow us to issue spot and see what other issues that Jimmy has, when we can refer him or his family or his guardian to somebody who can help him. For example, we do refer cases out to civil attorneys where we feel like that's an issue that we can't discuss with the victim, but they should talk to somebody. The most common issues that we do address are things like defense subpoenas for their child or victim's records. It's very common in criminal cases for the victims to get subpoenas for medical records, school records, counseling records, DHS records. And while the prosecutor can step in those cases, they often feel that it's better for the victim to have their own attorney. So we will step in those situations and file motions to quash subpoenas for those kind of records. There's a very specific process that is laid out in case law and statute for how defense attorneys are supposed to get victims' records, starting with a motion for pretrial discovery. So there's a couple of moments where a victim's rights attorney can step in and trying to protect those records and protect the victim's privacy. Another issue that we deal with fairly often is reasonable protection for the victims. So we ensure that victims are heard at pretrial release hearings, make sure that there's no contact orders, that there are reasonable protections for that victim, and that those protections stay in place. We can coordinate with the other attorneys in the case. For example, the district attorney, the dependency attorney, a civil attorney, to make sure that everybody is on the same page and the victim's rights are being protected and that the victim's best interests are at the forefront of the cases. We also receive notification from the DA's office for critical stage hearings, for things like plea negotiations, to make sure that the child has a say in what's going on. There's some critical stage hearings where the victim has a right to be heard. It's unlikely that Jimmy is going to be heard, but his attorney can be at that hearing and make sure that his rights are asserted and that his interests are heard. If in this case, Jimmy is 6 and he's unlikely to be receiving notification on his own. But in some cases, you might have a child who is 14, 15, 16, and is capable of receiving notification on their own. It's important to establish a relationship with the child, particularly with an older child, to ensure that that child is getting the notification if they want to get notification. You know, DHS will get notification, but for an older child, it may not be sufficient for just DHS to get notification. The child needs to get notification of events as well. So the first thing I would do if I were representing Jimmy in this case would be to file a notice of appearance of victims' counsel and assertion of victims' rights. It's pretty standard that we're asserting all of his rights, but if there is a specific right that I want the court to take notice of, for example, if I've been brought into the case because it's a subpoena issue, I'll file a notice of appearance, assertion of victims' rights, and in the body of the notice, I would say something like, we are asserting all rights on behalf of our client, and in particular, we are asserting the victim's right to refuse a defense discovery request. Because I want the court to be aware that this is a right that Jimmy has asserted, or we're asserting on behalf of Jimmy, and that we expect something to happen because of that. We let the DDA know that we're involved in the case, that we would like notification, that we want to be involved if there's going to be plea negotiations. Another important aspect is to think about restitution for your victim, for your child. Start talking to the DDA about restitution, thinking about what the expenses are going to be, and how you can help the DDA ask for restitution that's appropriate in this case. You know, in a situation like this, it's potential that Jimmy's going to have long-term counseling. You know, is that appropriate for restitution, or would a compensatory fine be better? These are all conversations that you can have with the DDA on behalf of your client. Coordinate with a dependency attorney as well. Make sure that that case is moving forward as it's supposed to. And make sure that the DA is communicating with you about any plea negotiations that are happening. So if you're going through with the case and you realize that something happened that shouldn't have happened, you know, maybe there was a critical stage hearing that occurred without notice to the victim, or some records got turned over without notice to the victim, you can file a claim of violation of victim's rights and request a hearing on that violation. And the form is available online. It's very straightforward. You just have to put in what the violation was, when it occurred, and most importantly, what your proposed remedy is for that violation. For things like, you know, if there was a release hearing where the victim wasn't allowed to be heard, you can ask that the release hearing be reheld so that the victim does have the opportunity to be heard, and you can go in and present to the court what you feel would be the appropriate release conditions to keep the victim protected. Once the claim is filed, the court should set a hearing and go forward with that. So when you're representing a child victim, the rights that you need to always be aware of and keep an eye on to make sure that they're protected are the constitutional and the statutory rights, plea negotiations that I've mentioned, right to be present, right to notice, right to be heard at sentencing. And that's a really important one. And it's really important to make sure that the DDA is aware that your victim wants to be heard at sentencing, if the victim does, or if you think it would be best. You know, there are situations where a case will proceed to a plea maybe on a status hearing day or something else, and the victim hasn't been notified that a plea is going forward. It's appropriate at that point for the DDA to tell the court that the victim does want to be there for sentencing and wants to be heard, so that the sentencing can be set at a different time. Like I said, restitution, and then post-conviction events. We do represent victims in post-conviction issues as well. So if you're going to be involved in the case for Jimmy and there's a possibility of post-conviction events, it's a good idea to just keep an eye on that so you know what's happening there as well. That is all I have. Any questions?
Thank you, Rosemary. Just sort of a wrap up. This CLE is on access to justice for children, and we've talked about 3 different justice systems that come into play when children are crime victims: the juvenile court system, the criminal court system, and the civil court system. And there are some there's some overlap in some of those systems in terms of what can be accomplished for a child to further their interest in justice. In the juvenile court system, obviously, the right to protection, the protection of the child is fundamental, but that's also a right that a child has as a victim in a criminal case. And that overlap exemplifies the need for the coordination among the various adults who are going to be necessary to achieve whatever justice these children can get as crime victims. No child can achieve justice in any form without the assistance of adults, including the adults who have presented during this CLE. There's also overlap in terms of the interest in compensation for injuries. The criminal justice system offers restitution and a compensatory fine to crime victims, but so does the civil justice system. And so coordination between civil and criminal justice practitioners to try and achieve compensation in the best and least harmful way to a child requires the coordination of those 2 adult advocates for the child. It may be easier to get compensation in the criminal justice system than it would be to subject a child to a potential deposition in a civil justice system. And the coordination of efforts between the adults, I think, is something that we should all keep in mind. The discovery in all 3 of those types of cases can implicate the rights of the children, as well as others, obviously. I mean, part of the protection of the child welfare statutes is not just the protection of the children's interests, but also the protection of others, the parents and other third parties whose information is contained in those records. So the coordination of the protection of the information is something that I think we should all keep in mind when we're advocating for children in any of the justice systems. And finally, the possibility of collective resolutions in some form, not necessarily in all 3 court systems, but there may be the possibility of collective resolution of some civil and criminal issues, some protection issues that would benefit from the collaboration and cooperation of the attorneys representing the interests of children in all 3 systems. So in closing, I would just like to urge people that are involved in all 3 systems to collaborate and cooperate with one another, because ultimately we might come out with better outcomes for these children than we would just acting individually. And the people involved in this presentation are collaborators. So we know it can be done, and we just need to work on our brethren and sisters to do it more. So absent any questions, I will wrap up by reminding folks that if you're interested in supporting crime victims' rights, then on April 21st, you can come to the Oregon Crime Victims Law Center Hardy Myers annual function and support us in that way, and support Meg Garvin getting an award that she greatly deserves after her years advocating for crime victims, many of whom are children. You can go to the Oregon Crime Victims Law Center's website to learn more about that function, or you can email me or Rosemary, whose contact information hopefully is somewhere in these written materials. But on the Oregon Crime Victims Law Center website, there's an information link as well.
Erin, I think someone is either giving us a high five or has their hand up in their box.
And Josh Ray has his hand up, and I'm not sure what that means.
I wanted to ask a question.
Are there places where people can volunteer to help people in these legal processes? Well, the most obvious answer to that is court-appointed special advocates. They help and are assigned to advocate for the interests of children in the dependency court system. And there's a great need for CASAs. There are pro bono opportunities for lawyers to advocate for children. The Oregon Crime Victims Law Center has a pro bono program that's certified by the Oregon State Bar. There are other crime victims law centers that have pro bono workers. There are pro bono opportunities for legal aid and similar organizations that advocate for some children, but the interests of children even in restraining order type situations. So those are the ones that come to mind. Josh is reminding me that he wants to play a video. So Josh, do you want to play the video?
We want to ask Ray his question. Ray Churba had a question as well.
Thank you. Thank you very much. I have a situation that I would like some input from anybody who's willing to give it. I have a case where there's an allegation of child abuse, and the child did not disclose to any officials, but a recording was made by a family member where the child disclosed. That recording was given to a police department in Oregon, and no copy was kept. So the only copy of this recording is with the police department. I have been over the statute that lists the conditions where the police can disclose evidence that they have gathered in a child abuse investigation over and over, and I do not see any way where it can be obtained in a civil lawsuit. And I was just wondering if anybody on this panel has run into the situation, has any ideas how a lawyer in a civil lawsuit could compel a police department to give up some evidence of child abuse that they have.
Well, we civil practitioners get a lot of information from police investigations, and it's typically by a subpoena in a civil suit. Your scenario raises other issues concerning the recording of sounds like a recording of a conversation that may have evidentiary implications because it's illegal in Oregon to record a conversation when not everybody knows that it's being recorded. That evidentiary issues the subject of some current legislation, but at this point in time, you can't use a surreptitiously recorded in-person conversation as evidence, full stop, period. There are exceptions, but I don't think they would apply in that case. But the short answer to your question is via a subpoena, and you're going to get kickback if there's an ongoing investigation, and they're not going to want to give it up until that investigation is over, which for a variety of reasons is not an uncommon response by law enforcement when there are potentially parallel investigations going on.
Thank you, Erin. I might email you further on this.
Okay.
And Ray, this is Rahila with DOJ. Very briefly, the other thing is if there is an open investigation, then DHS is required to contact the people that are involved in that investigation. In other words, the parents, the child. So if you are representing a client that may be a parent and they haven't heard from DHS yet, they can certainly reach out to DHS themselves and ask if there's an open investigation. Because I guess I am suspicious as to whether or not law enforcement on the basis of that tape even called the child abuse hotline, whether or not it was even evidence of child abuse.
Unfortunately, the investigation is closed.
Okay, so there was an investigation and that's now concluded?
Yes.
Okay, because it's surprising. Law enforcement will oftentimes then not disclose records, tell the requester that they won't disclose because they don't have the discretion under 419B035 to disclose, and send people to DHS Child Welfare.
That's exactly my problem. That's exactly my problem, because this recording is not in the Child Protective Services file. It's only with law enforcement, and they won't give it up.
Sorry, I got nothing else for you.
Yeah, it's interesting they won't give it up if they've closed the investigation, because it's not going to be used as evidence. And I would think that the person to whom the recording belongs would be entitled to get it back, but that's just a thought. We do have a question about whether there's a way to protect children from having to appear in court, which is often difficult for children. And interesting times, these COVID pandemic days, because in dependency cases, children are not appearing in court in person, are they, Rahila?
No, in fact, no one's really appearing in court in person these days. So, especially in this county, at least.
Yeah, but that's not to say that in criminal cases, you know, they don't have to appear in some manner in which the criminal defendant has the right of confrontation. And I know that there's always ongoing litigation about the manners of protecting children from having to be in the same room as the adult who did horrific things to them. And there's some state and federal laws that, yeah, confrontation in criminal courts. So there are some ways that have been carved out by state statute, and they get challenged. And Rosemary, do you have an answer to whether Oregon has a right of some other form of confrontation besides in person?
Yeah, there is actually a statute that allows for children to testify remotely or by closed circuit, I believe. But you have to, the prosecutor would have to prove that the child would be harmed more than a normal child would be harmed by testifying in person. It's a really, really difficult standard. And as far as I know, no DA's offices in Oregon have tried it, have done it. A couple have tried it. I know a prosecutor in Washington County tried to have his child victim testify by closed circuit, and the judge said no. So DA's offices around the state have reached out to us to talk about it, and they've all either opted not to try it or have been shut down by the judges. But there is a statute in Oregon that would allow it.
And I think there's also a U.S. Supreme Court case that addresses the issue, and I think the fear is that it would that there's a risk of having a conviction overturned on appeal if it were allowed and the standard were not strictly met.
Yeah, and that's why judges have shut it down in Oregon, because they don't want to see these cases come back.
And Paul Gom is putting Rahila on the spot. Paul, we were trying to keep DHS claims out of this, but this is for Rahila. Does DOJ have any philosophy or duty to report possible child's civil claim, even if it is against DHS itself?
So I really, so Paul, I can't necessarily speak to DOJ's duty. Now we are, you know, as AAGs, each and every one of us represent a specific public agency, a state agency. And so really as a CHAZ, as a child advocacy section AAG, my duty is to my client. And I think that that's no different than any one of us on this call in terms of when we represent a client. Our duty is to that client. And so I could actually run into ethical issues in terms of reporting on my own client. But when there are concerns about DHS's liability, that isn't to say that we aren't having those specific conversations with our client behind closed doors in terms of mitigating harm, in terms of their duties as a child's guardian, as well as legal custodian. So those are definite parts of the consultation and parts of the advice that we give. But in terms of kind of narking on my client, no, I think I would run into ethical issues were I to do that.
And probably
I was going to say, this is Emily. This is where I come in, NARC, so that Rahila doesn't have to worry about it. It's where I go to the judge for for her in some ways.
And the ethical issue Rahila had mentioned is undoubtedly why the notice requirement for tort claim notices under the Oregon Tort Claims Act has an exception for children in DHS custody. Since DHS is their legal guardian, DHS would be theoretically required to file a tort claim notice against themselves. And that's why there is no obligation to file a tort claim notice for a child who is injured while in DHS custody. So, any other questions before Josh plays his video?
And I don't have to play the video if you don't want me to, but that was part of the program.
Well, why don't you play the video and people can watch it if they'd like, but otherwise it is 4:32 and we've done our hour and a half. It's a great video. So hang out, watch it, and hopefully we'll see you on April 21st. Thank you to our presenters very much.
I was at the end of a difficult marriage when I returned home on September 2006. He had hired a man to murder me. My husband was sent to prison, and in 2014, he was due to be released. I wanted to know, had there been incidents in prison that would indicate to me that I needed to be fearful? The parole board victim advocate felt like I didn't need to have advanced information to help me prepare. My greatest fear is that he would come to murder me.
I was the chief of police of the city of Forest Grove. During that time, an individual damaged personal property and city property of mine. This went on for years. I retired in about 2008, and then it started up again. We started getting threatening phone calls, threatened to kill me, threatened to kill my wife. Even after 38 plus years in police work, I didn't know what I was going to do.
If someone feels like they have no voice, they feel powerless. If they feel like they're on their own, they get scared. If they don't know where to turn, they lose hope. The Oregon Crime Victims Law Center understands. That's why we provide free legal services for crime victims in Oregon to ensure that their rights are protected and that their voices are heard.
Victims can often be treated as witnesses instead of people who have been through this highly traumatic event. Representation allows them to take their voice back, to have a role and gain some sense of control back over their lives, which may have been lost through their victimization.
Since 2009, OCVLC has helped thousands of people all across Oregon find their voice in the legal system, including victims of domestic violence, assault, robbery, and many other cases.
I was exhausted emotionally, and I felt exhausted financially. So when I was able to receive help, I was incredibly grateful. They helped me obtain information about a conversation that he had had with a corrections officer. To me, that was critical information. It indicated that he had not ever acknowledged his crime and that he would be a significant risk to my physical safety and that of the people around me.
Victims often need someone standing by them to help them through the system. We are able to make sure that those rights that the Oregon Constitution guarantees them are protected and asserted throughout the justice process.
I made a call and set up an appointment to meet with him. I think I walked out from the first interview with weight lifted off of my shoulders. We actually started preparing for the trial for the permanent stalking order. As that trial progressed, I could see the judge really start paying attention. Then I started feeling like, okay, I've got somebody in my court and I've got a handle on this, and it's starting to come back together again, which was a huge relief.
Because OCVLC is a nonprofit organization, the work we do is only possible with your financial support. Every dollar we receive goes towards being the most effective advocate we can be for those who need it most.
It's critical that crime victims have support so that they can go from being a victim to a survivor.
I would encourage everyone to do what they could to support this organization to help victims of similar situations.
And that's a wrap. For those of you who didn't see the chat, the program should be in the Oregon State Bar's database within a few days. Make sure you sign up for the one from this date, February 18th, rather than from last October, because this one should have 1.5 credits versus just 1. So thanks to all of our presenters, and that's a wrap.
All right, we're signing off.